My name is Shaalu Mehra. I'm a partner at Perkins Coie here in Silicon Valley in our Menlo Park office. And I practice primarily in tech transactions and work a lot in open source licensing. So my presentation today sort of married those two interests. I have been quite interested in the sort of issues that arise in outsourcing transactions and in joint ventures in light of open source software that is distributed in those transactions or that is developed or modified in these types of arrangements.
This sounds like a complicated landscape. What is happening with joint partnerships in the GPL?
So it's interesting. There's a lot of language in the GPL version 2, or there's commentary about these types of arrangements provided by Free Software Foundation and its FAQ for version 2 of the GPL. And version 3 of the GPL tried to address the outsourcing arrangement and outsourcing situations in particular. Section 2 of version 3 of the GPL has a fairly well-defined, circumscribed exception to its terms that apply in an arm's length transaction between a customer and a vendor. However, as I discussed in my presentation, the carve-outs that are provided in version 3 of the GPL don't really apply in a situation where you have co-collaborators in a joint venture. Now, as I discussed in my presentation, I think there are some limited cases where two parties could create a joint venture, share 50-50 ownership of the joint venture, and be able to have code developed by that joint venture and exchange code with the joint venture without engaging the copyleft requirements of the GPL. I think that's in a very narrowly circumscribed case, one that I elaborated during my presentation. And by and large, the situation I think under the GPL is that any sort of consortium that is developed for modification of existing GPL code licensed by a third party is going to be immediately subject to GPL requirements, which is different from the situation where a consortium is developing code sui generis, which they develop internally and elect to release publicly pursuant to the GPL at a later date. That situation is possible. It's sort of analogous to the dual licensing situation where you have these commercial entities coming up that retain all title to the copyright themselves, and then at a later date elect to license that under the GPL. They are able to do that because they're not under any GPL obligations to third parties. But it creates a sort of interesting situation where it arguably makes it more likely that a consortium will be able to develop GPL code if it develops the code sui generis than it is for a consortium to take an existing GPL product licensed from a third party and develop modifications to that it elects to release at a later date.
This will be a broad question, but how is this going to affect innovation and the pace of innovation?
It's an excellent question. So we are seeing lots of, and have seen over the last several years, lots of consortia created to develop code for platforms based on open standards, software platforms and hardware platforms. We're seeing it in mobile telephony right now. We're also seeing it in the application space, in the enterprise application world and otherwise. I think there's a possibility that as these consortia arise, that players are going to want, the participants in these consortia are maybe more inclined to participate in them if they develop the code originally in-house, have proprietary rights to it, and elect to license that subsequently under copyleft type terms. It may be that that situation may be more appealing to the vendors who are in these consortia than the possibility of developing on top of an existing project such as Linux, because the GPL obligations will apply immediately. I haven't seen any evidence of that yet, but it's definitely a theoretical possibility. And I think as these consortia are becoming more prevalent, and as we're seeing them announced on a regular basis, and given the stakes that are involved, particularly the involvement of vendors with very large patent portfolios, which are going to be subject to the patent defense provisions in these open source licenses, I think there's a possibility that the lack of a carve-out for these types of consortia could cause vendors to gravitate towards closed platforms that are subsequently outsourced or subsequently licensed on an open source basis, rather than developing on existing platforms, which I think would be sort of contrary to the purpose of the GPL.
It occurs to me that when we talk outsourcing, that a lot of companies have within their stack of software solutions software they may not be aware of. Mm-hmm. As more and more companies look to outsource, how much more due diligence are they going to have to be applying to what they're providing their customers?
That's an excellent provision. So as somebody who works in the outsourcing space, we always recommend that both customers and vendors undertake extensive due diligence, even in the absence of open source code. It's obligatory to do so, to know what sort of licenses to third-party software or any third-party intellectual property is necessary and is being exchanged between customers and vendors. However, I think it takes particularly importance in the open source realm, and just given the current environment where, as I mentioned in my presentation, open source is ubiquitous in every IT environment. And although customers may not realize this when they're entering initially into an outsourcing transaction, there will inevitably be distribution of open source code when they're entering into any sort of outsourcing transaction. And as a consequence, in theory, every time there's a distribution of open source code, you've created a new instrument, a new legal instrument. Whether it's a license or a contract remains to be determined, but a new legal instrument over and above the base agreements that you have governing the relationship between the customer and the vendor. And each one of these licenses has differentiated terms regarding the scope of reciprocity, regarding the patent defense provisions. You know, the GPL 3 has all sorts of interesting ancillary clauses that have been added to it, such as the clauses on DRM. And so as a consequence, there are license terms in each one of these packages that need to be taken into account once you've determined what open source packages are going to be licensed, once you determine how those packages are going to be accessed by either the vendor or the customer, whether there's going to be an actual distribution, whether the vendor's only going to access it remotely from a customer network, once you decide which of customer or vendor is going to be making modifications to the code. All of these considerations factor into the determination of the scope of the license. You also have to determine who the third-party licensors are for these packages, what the provenance of the code is, not just to have comfort regarding third-party IP risk, but also to assess what the interpretations of these licenses are by these third-party licensors, as well as to get a sense of litigation risk.
Mercy. So let's talk monetizing free and open source software. Mm-hmm. Different organizations I've been interviewing seem to approach this in one of two ways. There's, let's call it the open NMS model, which is a completely free and open source software mm-hmm. solution, and the monetization comes from the tier 2 support. Yeah. Some of the PBX entities, software PBX entities I've spoken to, they start with a core of the free and open source stack that's under GPL, but then they will have for their licensed product certain enhanced graphical mm-hmm. user interface twists, and maybe even some modules that were not available. Is there a legal morass in either one of these?
Well, so it's, I think, an interesting development as somebody who's been working in open source licensing and interested in these issues for probably a dozen years now, to see how business models, how many different business models have proliferated around open source code. And I think it speaks to the foresight of GPL version 2 that all of these models have been made possible. You have the model.
One second. One of the wonderful things of doing live interviews at Linuxworld is sometimes people try to clean the room. Maybe you'll finish.
So as I was mentioning, I think it's a testament to the flexibility and the foresight when version 2 was drafted in 1991 that we have seen all these different business models proliferate, which have been compatible with the license. So there is, as you mentioned, there's the model of providing support services in conjunction with code, where the vendor develops modifications to an existing packages, releases all of those modifications under the GPL, provides support, and essentially their barrier to entry, the reason why they have a viable business is because they're on the leading edge of being able to provide that support by virtue of being the leaders of the project and by virtue of having a governance role in the project. Typically what you see is that the sort of support model that you're talking about works when the vendor is an active participant in the development of the code, participates in the governance of the code, probably directs the development of the code in a way that's favorable to their own business model. And so they will have an inherent advantage over another party, which is trying to provide support services for that code, despite the fact that they're releasing everything under the GPL. However, that's only one of many models. There is the other model that you referred to, where a vendor will distribute an open source platform and then have proprietary applications that run on top of that platform, which is permissible, expressly permissible under license such as the GPL. And then they provide ancillary supports for the complete package. There is, of course, the dual licensing model, which I was referring to earlier, and which has been so prominent the last 2 to 3 years, where you see these startups that have emerged. I think even longer than that, going back to MySQL, where you see startups emerged who retain all the copyright in their own code so that they have title to the code, and they then, as a consequence, have the option to either license that code under a proprietary license or under the terms of the GPL3, because they aren't in turn bound by any reciprocity obligations to a third party. So that's another viable model. So the proliferation of these models and the differences between them, I think, just speak to the viability of open source licensing as a business proposition.
Outstanding. Maybe you could tell us again what firm you're with.
Mm-hmm. I'm with Perkins Coie.
And how long have you been involved in free and open source software licensing? And
sure. So I started law school in 1995 and took an active interest in open source issues at the time. Evan Moglen's at Columbia Law School, and I worked with him while I was there. And it has been part of my practice since I've been practicing. I've been practicing in Silicon Valley for 10 years now.
I truly appreciate the time you provided in today's presentation, and also give the community some really direct and actionable information on this thing called the GPL, free and open source software in business development.
It was my pleasure. Thank you.
Thank you.